Assistant Attorney General Clarke is well known to this audience, and for good reason. Her commitment to the cause of civil rights and the rule of law have led her to really extraordinary accomplishments. She's the daughter of immigrants from Jamaica and grew up in New York. She graduated from Harvard College and then the Columbia Law School and began her legal career at the Civil Rights Division of the U.S. Department of Justice, the division that she now leads. She left DOJ to join the NAACP Legal Defense Fund to help lead LDF's work on voting rights and election reform, which is a powerful thread that runs throughout all of her work up to today. In fact, she argued at the district court level the Shelby County, Alabama case that ultimately went to the Supreme Court. She went on to lead the Civil Rights Bureau at the New York Attorney General's office. And in 2015, Ms. Clarke was named President and Executive Director of the Lawyers Committee for Civil Rights Under Law, an organization near and dear to all of our hearts. In January of 2021, wasting no time, I would note, President Biden nominated Ms. Clarke to serve as the Assistant Attorney General for the Civil Rights Division, and the Senate confirmed her a couple of months later. I would underscore the first time that the Senate had ever confirmed a woman to be the head of the Civil Rights Division, and that is worthy of a moment of applause here tonight as well. So we could be here all night talking about the many legal victories and courtroom accomplishments that Assistant Attorney General Clarke has racked up over the years. There's simply not enough time for that. So I want to take just a moment and focus on some of the things she's done in the 2.5 years that she's been Assistant AG for Civil Rights. First of all, it's worth highlighting, especially on this night, honoring this extraordinary lawyer, that the fight for Native American civil rights is far, far from over. Just last year, under Assistant AG's Clarke's leadership, the Civil Rights Division sued the Grand Gateway Hotel and Cheers Sports Lounge and Casino in Rapid City, South Dakota, under the Civil Rights Act of 1964. Why was that necessary? Because they were refusing to serve Native Americans in 2022. There's work to be done, and thank you, Assistant Attorney General Clarke. Just in June of this year, a month and a half ago, the division released its findings that Minneapolis and its police department had engaged in pattern of practice of conduct violating the Constitution and the law. Among other things, the Civil Rights Division findings held that the police department had discriminated against Black people and also against Native American people in its enforcement activities, including in the use of force following stops. More broadly, under Assistant AG Clarke's leadership, DOJ has greatly increased its police department pattern of practice investigations. There are 7 public investigations underway now, and you may recall that in March this year, the department released its findings with respect to the Louisville, Kentucky Police Department. More than 50 cases, criminal cases, have been brought involving police misconduct under the leadership of Assistant AG Clarke, and the division has secured more than 40 convictions in those cases. And as what is really a sad commentary on our time, but a reflection of the work the Civil Rights Division must do, the Civil Rights Division has prosecuted more than 90 defendants for hate crimes since January of 2021. Assistant Attorney General Clarke has miles to go before she sleeps, and I think it's critical that you know, Assistant Attorney General, that everyone in this room will be with you every step of the way. Would you all please join me in welcoming and honoring Assistant Attorney General Kristen Clarke, our keynote speaker tonight.
Good evening. Thank you so much, John, for that very, very gracious introduction. It is wonderful to be with all of you this evening. It is a great privilege to be with all of you today especially because the host of this event is the ABA Civil Rights and Social Justice section. I extend my greetings to your chair, Juan Thomas, to Chair-elect Robin Rung, to ABA President Deborah Enix Ross, to incoming ABA President Mary Smith, to Fred Gray, to U.S. Attorney Cole Finnegan and Rob Weiner, and so many of our distinguished guests this evening. The ABA is the voice of the legal profession and the guardian of the rule of law. And this committee, the Civil Rights and Social Justice section, is no doubt the conscience of the ABA, the hub for civil rights lawyers, and the prime mover for projects that address some of the most important issues of our time. I'm also thrilled to be here as the section honors John Echohawk, a steadfast champion of Native American rights. Congratulations, John, and thanks for all that you do. And I would also be remiss if I didn't say a brief word about Charles Ogletree, a true legal giant. Tree, as he was affectionately known, was a brilliant scholar, a tireless advocate who believed deeply in the right to counsel for the poor. He was the son of migrant workers who used the law to stand up for victims of injustice. He was an advocate for the survivors of the Tulsa race massacre and a civil rights lawyer truly molded in the finest traditions of Justice Thurgood Marshall. So we will miss Charles Ogletree, who stood right here as your keynote speaker for the Thurgood Marshall Award Program in 2001. Now, I'm humbled to have this opportunity to address you this evening because Justice Thurgood Marshall is truly one of my heroes. I previously worked at the NAACP Legal Defense Fund, which he founded in 1940. He was a trial lawyer, appellate advocate, strategist, spokesperson, and devout civil rights leader. And he used the law to weave justice into the fabric of our nation. Justice Marshall put his life on the line repeatedly, venturing into the most violent racist jurisdictions in our country, places where challenging racial apartheid could get you killed, where Black defendants almost were always convicted by all-white juries, where Marshall's mere presence as a Black lawyer was regarded as a serious provocation, particularly by law enforcement. But Marshall took those threats in stride. He told a story about being chased by a lynch mob, but not just any lynch mob. The leaders of this one were local sheriffs and his deputies. He recounted how, when he was trying a case in a southern town, the local newspaper printed on the front page, "We don't advocate violence, but for those interested, NAACP lawyer Thurgood Marshall is staying at the following address." And Marshall described the time a deputy sheriff warned him that he'd better be on the next train out because no Black person, and that wasn't the word that he used, had ever survived the night in that county. And as Marshall put it, he packed up his constitutional rights and got on the very next train. Justice Marshall talked about growing up in segregated Baltimore, and once as a teenager, he was downtown and found that there was no bathroom that a Black person was allowed to use. He had no choice but to get on a bus and head home. He only made it to his front steps. Decades later, Marshall described that event, not the attacks and the abuse and the death threats, but that event as the most humiliating moment of his life. And I tell that story because it conveys in the most primal way the indignity and inhumanity inflicted by racism. The accumulation of those abuses fueled Marshall's burning sense of justice, his commitment to the intrinsic worth of every human being, and what he called in Brown his dedicated belief in a colorblind Constitution. In my time with you this evening, I want to describe the work that we are doing at the Civil Rights Division of the U.S. Department of Justice to carry out the legacy of Marshall's work. I take seriously our role as the highest civil rights law enforcement agency in the country. As we all know too well, far too many people in this country still confront the stigma and sting of racism and discrimination and even violence simply because of who they are, where they come from, what they look like, or who they love. While this work is challenging, I want you to know that the Civil Rights Division remains as resolute as ever. I'll start with one of the major cases of this Supreme Court term, one that Seth Waxman knows particularly well, Students for Fair Admissions versus Harvard, the recent decision on race-conscious college admissions. Several justices debated Marshall's legacy regarding a colorblind Constitution. Of course, Marshall had far too much experience with the harsh realities of racism and massive resistance. He had represented far too many doomed clients, appeared in far too many kangaroo courts to view colorblindness as a near-term mandate rather than an ultimate objective. By 1978, in his dissent in Bakke, the long struggles led him to a sober assessment. The civil rights victories of the 40s and 50s, Justice Marshall said, quote, did not end segregation, nor did they move blacks from a position of legal inferiority to one of equality. The legacy of years of slavery and of years of second-class citizenship in the wake of emancipation could not be so easily eliminated. For far too long, Marshall continued, positions of influence, affluence, and prestige in America were closed to black people. If we're ever to become a fully integrated society, one in which the color of a person's skin will not determine the opportunities available to him or her, we must be willing to take steps to open those doors. And SFFA was about one of those steps. Diversity as a basis for considering race is one among a number of factors in college admissions. The court dismissed the university's assessment of the educational benefits or even the relevance of racial diversity in that setting. But as Justice Jackson observed in her dissent, the notion permeating the decision was that it is unfair for a college's admissions process to consider race as one factor in a holistic review of applicants. Justice Jackson's powerful refutation of that notion echoed Justice Marshall's reflections in Bakke. She said that our country has never been colorblind. Given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. The opinion was a disappointment, but this moment has reinforced our fervent commitment to promoting equal educational opportunities for all students, addressing barriers to diversity in higher education, and doing so within the legal boundaries set by the court. SFFA may have made it harder to expand opportunity and diversity, but while the path may be difficult, in the civil rights community, we are used to difficult. This is a moment to rededicate ourselves to achieving equal opportunity and diversity on college campuses and in society. Right now, the Department of Justice and the Department of Education are developing a resource document that will issue soon, advising schools, students, and other stakeholders on how to seek the benefits of diversity and equal opportunity within the limits set by the court. For example, schools can align their admissions policies with attributes they most value: hard work, achievement, potential, grit, including consideration of how race affected an applicant's life. In SFFA, the court stated that a university could consider a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal when it is tied to that student's unique ability to contribute to the university. This moment also presents an opportunity for schools to examine admissions preferences and policies broadly, to confirm whether those preferences and policies directly relate to an applicant's individual merit or potential, and to ensure that existing metrics or criteria do not exacerbate existing inequality or disparities. Our work in the Civil Rights Division, of course, encompasses more than higher education. We are also deeply focused on the crisis of hate crimes and bias-motivated violence that's gripping our country. FBI statistics show that hate crimes increased nationwide by more than 11% from 2020 to 2021. That includes, since January 2021, we've charged more than 90 defendants with bias-motivated crimes in more than 80 cases, as John noted. That number includes charges against the man who killed 10 black people with an assault weapon at a Tops supermarket in Buffalo, New York, because black people were supposedly trying to replace whites in this country. That number includes our prosecution of 3 white men in Georgia who killed Ahmaud Arbery simply because he was black. It includes the defendant sentenced to 90 consecutive life sentences for killing 23 people and wounding 22 more at a Walmart in El Paso, Texas, targeting his victims because of their Hispanic identity and national origin. It includes the defendant recently found guilty of a grim anti-Semitic attack at the Tree of Life Synagogue in Pittsburgh, Pennsylvania, that resulted in the loss of 11 lives. It includes a Texas man who received 25 years for a knife attack on an Asian family he believed was responsible for the COVID-19 pandemic. It includes a Missouri man sentenced this Wednesday to 16 years in prison for setting fire to an Islamic center on the first day of Ramadan. In all, since January of 2021, we've convicted more than 70 defendants for hate crimes. There is great urgency behind this work. No American in our country should be killed or subject to violence or threats of violence based on their race, religion, national origin, sexual orientation, or gender identity. We have also made it a high priority to hold law enforcement officers accountable when they violate people's civil and constitutional rights. Such misconduct erodes public trust that is essential to effective law enforcement in our country. We secured convictions against Derek Chauvin, the former Minneapolis police officer who killed George Floyd, and the 3 officers who stood around and watched, who failed to intervene and failed to render medical care, actions that might have spared Mr. Floyd's life. It includes 4 officers who we recently indicted for their role in the tragic death of Breonna Taylor. And it includes several officers who pleaded guilty this past Thursday in Rankin County, Mississippi, for a heinous, brutal assault and torture of 2 black men. One of those men grew up singing in his church's choir and will likely never sing again after one of the officers rammed his gun into the mouth of one of the men, carrying out a mock execution resulting in the discharge of a bullet that tore his tongue, broke his jaw, and exited through the back of his neck. Since January of 2021, we've prosecuted more than 50 cases of police misconduct and obtained more than 40 convictions. And a simple core principle guides this work. No one is above the law in our country, period. We are also hard at work working to promote constitutional policing. And just over a week ago, launched a pattern and practice investigation into the Memphis Police Department, where the recent killing of Tyree Nichols signaled potentially broader issues. In June, as you heard, we announced the results of our investigation into the Minneapolis Police Department, where we found a pattern or practice of misconduct, including excessive force, discrimination against Black and Native American people, retaliation against protesters and journalists engaged in the exercise of their First Amendment rights, and discrimination against people with behavioral health disabilities responding to calls for assistance. We're now negotiating a consent decree to institute the reforms necessary to cure these issues. We announced similar findings in Louisville, Kentucky, and currently have investigations pending across the country in Phoenix, New York City, Louisiana, and more. All Americans deserve fair, non-discriminatory, and constitutional policing in our country. Lastly, I want to mention our work to safeguard the right to vote, the most important civil right in our democracy. In Texas, we challenged a law that impairs the rights of Black and Latino voters to vote absentee and to receive help from the person of their choice. This week, we began trial in Galveston, Texas, where we're challenging a discriminatory redistricting plan that denies Black and Latino voters an equal opportunity to elect candidates of choice. In Arizona, we have sued to stop unlawful restrictions on voter registration. And last month, we challenged a new Mississippi law mandating appointment of hand-picked special judges and prosecutors by white Mississippi state officials in majority Black Hinds County and the city of Jackson. We allege that the state unconstitutionally created this new two-tiered system of justice, displacing elected Black officials and populating a new system with judges and prosecutors appointed by white state officials. This thinly veiled state takeover singles out Hinds County's predominantly Black electorate for adverse treatment imposed on no other voters in the state, shifting power and resources away from officials democratically elected by Black voters. Countless Americans, civil rights leaders, faith leaders, ordinary citizens fought and died to secure the right to vote. They stood up to brutal assaults and even lynchings. And we can't forsake the sacrifices of those heroes. We will fight to ensure that every eligible American can exercise the right to vote and have voice in our democracy. Tomorrow, August 6th, marks the 58th anniversary of President Johnson's signing of the Voting Rights Act. So it is an ideal moment to reaffirm our collective commitment to eradicating voter suppression and voting discrimination. There is more that I could say about our work, about our efforts to advance environmental justice, our work to combat modern-day redlining by banks and financial institutions, our fight to protect the rights of people with disabilities, including our recent announcement of a proposed rulemaking to address website and mobile app accessibility for people with disabilities, our work to address unconstitutional conditions in our jails and prisons, our efforts to ensure that our workplaces, schools, and local communities are free from discrimination, and more. But it suffices here to reiterate our determination to stand up to discrimination wherever it rears its ugly head, and to fiercely defend the civil rights of all people in our country. Thurgood Marshall was a brave and valiant champion of these civil rights, and in giving this award to John Echohawk tonight, we rekindle the inspiration of Marshall's example. We draw strength from Marshall's faith in the rule of law and in his belief that lawyers can make a difference. And we remind ourselves that while we stand on Marshall's shoulders, we still have to keep rising. The challenges that we face are formidable. The murderous forces of hate and bigotry are stubbornly entrenched, and the half-life of discrimination spans many generations. But as Congressman John Lewis reminded us, ours is not the struggle of one day, 1 week, or 1 year. Ours is not the struggle of one judicial appointment or presidential term. Ours is the struggle of a lifetime, or maybe even many lifetimes, and each one of us in every generation must do our part. If all of us in this room tonight, judges, attorneys, policymakers, advocates, and citizens concerned about protecting our democracy and ensuring equal justice under law, approach these challenges with courage and conviction, with fidelity to the Constitution, and with empathy for those who are suffering, there is no doubt that we will bring about the better future that all Americans rightly deserve. Thank you so much for having me this evening.